Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanti Reddy to discuss the latest updates on immigration, perm process, followed by Q&A session. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. Hello, Prashanti Garu. Welcome to the show. How are you doing?
Hi Ranjit, how are you?
I'm good. I'm good. Thanks. So, can you please provide latest updates on the immigration before we get into our regular topic?
Yes, the updates for this week, I guess one is that there was recently a case that was decided for this will help in the IT sector because the court basically decided that computer programmer is a specialty occupation. That's a big deal because courts are usually not willing to overturn specialty occupation denials. But in this case that they did, and they said, and for years now, USCIS has been saying computer programmer is not a specialty occupation. I think this started, a few years ago. Before that, we would file a lot of cases with computer programmer, systems analyst, programmer analyst. And then slowly, what was happening is USCIS was tightening or decreasing the number of occupations that you could file that they consider to be specialty occupation, and therefore, very few occupations are there right now that are considered to be specialty occupations. So one of the first one that was hit was computer programmer, and also the fact that when Trump first came to power, he issued an executive order, and it was specifically on computer programmer. He didn't say that it's not a specialty occupation, but he said that it has to be looked into closely. So there was a memo from USCIS about computer programmers. And so with that, pretty much it was like a death knell on the computer programmer position. No one uses it. Attorneys prefer not to use it. And computer programmer is good because the wages are lower when compared to the other jobs that we now tend to use, which is software engineer. I think the reason they did this is also so that only higher waged people could, get a H1. So they removed computer programmers, programmer analysts, or systems analyst positions, which are slightly higher than computer programmer positions. Even that, they started saying it's not a specialty occupation by quoting something called the Occupational Outlook Handbook, and they were quoting it in such a way that so they were kind of closing the gates more and more and restricting the definition of specialty occupation more and more. And so with systems analysts, they said that, because as per the Occupational Outlook Handbook, which is a publication of the Department of Labor, they said as per that, since it says in that a bachelor's degree in computer science or engineering or math is required, it's not specific. So specialty occupation, in order to qualify, the job has to require a specific bachelor's in a specific field. So computer science only. If it says engineering, then it's too vague. So that was one more way that they kind of restricted the occupations again. And computer programmer, again, they said that before systems analyst itself, they started off with computer programmer, but they said that as per the Occupational Outlook Handbook, most occupations require a bachelor's degree, but it doesn't say all occupations require a bachelor's degree. So the overhead says most require, but there are some employers that will also accept less than a bachelor's degree. So USCIS just interpreted that as not being a specialty occupation. So in this latest court case, the judge said that first thing is there's no reason to follow Occupational Outlook Handbook. It's not like the Holy Grail or the Bible or something that it has to be followed so religiously. Nowhere in the regulation itself does it say that you have to follow the Occupational Outlook Handbook. So that's a big plus. So if the employer is able to show otherwise, that industry standards are that most jobs require or it's common for a bachelor's degree to be required for a computer programmer, that's enough. You don't have to show that most require or some require or majority require. All you have to show that it is common in the industry as per the regulation. And USCIS has been shifting this definition further and further to make it more and more restrictive. So they've put a stop to that. So what does it mean for us and our clients and for you? Basically, you can quote that case. It's a district court case, and if there is an RFE on your case, you can quote it and say, look, as per this judge, computer programmer is a specialty occupation, and simply because we are showing this through the job duties, and we are showing that you have to be able to show it in each case. And so they just can't blindly quote the Occupational Outlook Handbook. So it makes it easier for computer programmer. So for those who have entry-level positions where the pay is, of a software engineer is too high, we can start thinking about using computer programmer as an alternative. So that's the good news. Again, we'll wait and watch and see, because there's regulation also, right, with reference to specialty occupation. And of course, there's an injunction on that, but it hasn't gone away completely. So I think we will know in the next few months as to where the law is with reference to what is specialty occupation and what is not, and which positions qualify. So we'll have a better idea. The other update is with reference to the visa bulletin, much awaited every month, and especially these last few months. But it's disappointing news because they're not allowing us to use the dates for filing. So that's bad news, because the dates for filing were much ahead, and a lot of people were able to file their cases in October and November, as well as December. So January, they're going back to final action dates. And so again, it's a huge backlog. Final action dates haven't moved much, a week or so. So, that's not good news. So for all those people who have filed in October, November, if the cases come back, and that's the scary part, then, you won't be able to refile it because in January, visa numbers are not available, most probably, for your priority date. So those are the two updates that I wanted to give this week.
Sure. Thanks, Prashanti Garu. Today's topic is, about the POM process workshop or whatever. Can you please, explain each and every requirement and step that are involved in the labor or POM process?
To start off with, for the labor certification, most occupations require a labor certification to be filed. If you want to get a green card based on employment, there are some exceptions, of course, to this labor certification process. But I guess we can get into that later. Just to start off, if your occupation or the job requires a labor certification, then the first step is to identify the job duties, identify the job requirements, and file a prevailing wage with the Department of Labor. The prevailing wage, in the prevailing wage form, you are putting in all the requirements, and then the DOL will approve it. Right now, it's taking about 2-3 months for approval of prevailing wages. They will send you what they think the wage level should be. So based on that, you have to, put in that wage level in your advertising. And you can start, then the next step would be to start the advertising process. The advertising process can be started simultaneously. Most of the steps can be started along with filing of the prevailing wage, because most advertisements don't require you to mention the wage. All that's required in an advertisement is, a brief job description, so that the person who's reading it can figure out, what the job is. And of course, your address, and if there are any travel requirements or any remote work requirements, then those have to be mentioned. And of course, your city and state, job title. I always mention the educational qualifications required for the job and the number of years of experience. So those are what we mention usually in an ad. We don't usually put the wage. The wage has to be mentioned in only one of the advertisements, which is a notice of job opportunity, and that has to be posted internally. Anyway, that has to be posted on your website or actually in your work premises, so on the wall in your office. So that can be done later, and it has to be done for 10 days, and then you have to wait for 30 days after that for resumes. But the rest of the ads, so to break it up, we have several ads that have to be placed. It's a total of 5 ads. So you have to place 2 consecutive Sunday newspaper ads. You have to place an online ad. Then you can also do employer website. You can do a referral program, which means that your employer has a referral program whereby they give certain incentives to their employees if they refer someone. So those are some of the ads that have to be placed. Altogether, it's 5. You have a choice, of course, and they put it out in the PERB regulation as to what are the different ads that can be done. And out of that, you have to choose 5. Sorry. So the compulsory ads are the newspaper and the Department of Labor website, the NOJ, that is a notice of job opportunity that we were talking about. Those are the compulsory ads. The other 3 ads are, you can choose between various different ads: referral program, employer website, online ads, publications, actual print publications. It could be television ads, radio ads. So depending on the type of job and what is appropriate, you can choose what you want to do. So once the ads have been placed, you've identified the job and the requirements. You've sent out the prevailing wage. You've done the ads that you can do which don't require the wage to be mentioned in them. Then once the prevailing wage gets approved, you can go ahead and do your NOJ, and then there's a waiting period. Remember, for every ad there's a waiting period of 30 days after the last ad is placed. So we're talking about at least 60 days to 90 days time that will be required for this recruitment process. So once you place the ads, if you get any resumes, you're supposed to look at the resumes. And if you find any qualified resume applicants, then you're supposed to interview them, and you have to record everything. So if you're not interviewing them, then you have to write a recruitment report saying why you didn't interview them, why you think they're not qualified. If they're even halfway qualified, then it's better to interview them and then record what happened at the interview and why they were rejected, what they didn't have that is required as per your advertisement. So you can't put in requirements that you cannot reject people based on requirements that are not there in your PERM. So you can't say that you needed C++ when that's not mentioned as a skill in your advertisements. Actually, not in your advertisements, but in your PERM, when you file the PERM. Remember, the advertisements can be very brief, so you don't even have to mention the skill sets in the advertisement. You can just say various skills required. But when you're actually filling out the PERM, which is the next step now, you have not received resumes, or you've received resumes that you have been able to reject because they don't qualify. And you also have to show that if you've rejected them based on certain skills, that it was not possible to train them. Sometimes the Labor Department will say that, why were you could have trained them if it was something simple that they can be trained in. So you have to show that it's not simple, that C++ is complicated, and you don't have the means or the know-how to train them, and it takes time as well as money to have to train them after they join you. So the reasons for rejection have to be reasonable. You can't reject it based on something that is unreasonable. Also, it has to be within as I was saying, what is required in the PERM. So now you're filling out your PERM form. If you have rejected them based on C++, then make sure you put that in the PERM application as a special requirement. Put in your job duties, your job requirement. If you've rejected somebody based on a bachelor's, and if you don't put in the requirement of a bachelor's degree in your PERM application, when you're filling it out, then obviously it's, your case is going to be rejected. So you're filling out the PERM. If you don't fill out certain information in the PERM, then also you could get a rejection. For example, if, as I was saying, in the job duties, if of course in the advertisement you have to mention certain things, as I said, with reference to travel, relocation. Also, if they're roving employees, if you're in an IT kind of environment where your employee works in different client sites, you have to mention that. You have to mention the language of a roving employee. So certain things have to be mentioned, and if they are not, then it could be rejected in an audit. It could also be rejected in the I-140 stage if they don't audit your labor certs. So you have to be careful with how you what you put in the perm. So once the perm is filed online, and once you file it, two things can happen. You could either get an audit, and if you get an audit and if you don't respond to their satisfaction, then they could ask you to do the recruitment again, and it could be supervised this time. So supervised by DOL. All the resumes will go to DOL. It's much more difficult, obviously. So that's called supervised recruitment. So that could happen. But if they're satisfied, then there could be an approval, or you could get an automatic approval without an audit as well. But nowadays, a lot of labor certs are being audited simply because of COVID and the DOL's perception of how the labor market is. They are clamping down on audits and issuing more audits. So once it is approved, then of course you go ahead and file the I-140. The labor is valid only for 180 days, and it will be written on the certification as to what the validity period is. And before the validity is over, you have to make sure that you actually file the I-140, right? If it's denied, then you can go to BALCA, which means you can appeal the case. People mostly prefer to simply refile unless there is a priority date issue or some such issue which they cannot get back. Okay, it's just easier to refile rather than going to BALCA or rather than appealing, because a BALCA can take up to 2-3 years or more to be resolved, and at the end of it you don't know whether it'll be approved or it might be denied again, and then you're wasting a lot of time. So unless you have some compelling reasons to appeal, most people will fix the problem if they can, and then they will refile. So that is, in a nutshell, how the labor cert process works.
Thanks, Prashanti. Before getting into the next question, I have, it's off topic, but, this has been asked a couple of times by a member offline. So I just want to put that question. Yeah, the situation is he has a daughter who is born in Nepal. His filing dates are current, but not final action dates. But he was just wondering, because his daughter is born in Nepal, is there any use that cross filing something,
The cross filing, as far as I know, and again we can verify that next call, but cross filing is for spouse interfiling. I don't know if it applies to children. I think it applies to spouses. So if that's a child, if the spouse is from Nepal, then yes, cross-charge. It's called cross-chargeability, and it can definitely be. You can use the priority date of the spouse. You can use the nationality of the spouse, and then, for example, if you're from India and the spouse is from Nepal, worldwide is much better, and some categories are even current. So you can go ahead and file the 485.
So, it may not be applicable to kids, you mean to say?
To children.
Okay. So we'll anyways confirm in the next show. But yeah, that's what it is. Okay, yeah. And coming to the perm, what are the costs associated with the perm? Do we need to pay for the perm, or any costs before or after the perm?
So basically, the good thing is so far the Labor Department does not charge for perm, but that might change very quickly. They have been wanting to charge for perm for a long time now, but they haven't been able to do it because there is some technical issues involved with that, and they haven't been able to overcome those. So there is no charge from the DOL for perm, but you have obviously costs involved. The advertisement costs are quite significant because you have to do 2 newspaper ads. And depending on the size of the ad, it could go from $1,000 to $2,000 for the ad itself. You have the attorney fees. You have other ads. You could choose all free ads, but if you don't, then there could be other costs involved with the other ads as well, the optional ads. One of them is publication. Publication in, for example, a computer journal, in a print journal, can be very expensive as well. You can use online ads, can cost money, but there are a lot of free online ad options. If you use Monster or Dice, that will cost money, but otherwise you could use a lot of free, like Indeed and some other websites that don't charge. So it depends really on the number of words. So it's advertisement cost is the main cost, I think, for the perm.
Okay. And how about, you said the ad goes with the number of words. How about the cost associated with filing any PWD?
There is no cost with prevailing wage. Prevailing wage is free. Again, the DOL has not as yet initiated a cost for prevailing wage or LCAs, but there was recently in the bill, Fairness for Immigrants Act bill, there was a proposal to charge a fee for the LCA. So it might be happening in the future, but right now there is no fee. And I just wanted to confirm, I did a quick search and there's no cross-chargeability for children. So it's only for the spouses. So just to answer that question, which you had asked earlier.
Oh, okay. Sounds good. So yeah, coming to the next question, is there any way to get around the perm? I mean, is it mandatory for everyone or, is it optional for few? What are the situations if it's optional? Who are all exempt from the perm?
So there are many situations in which you can get a green card through employment, but perm is not required. You have religious workers, EB4, where directly I-140 can be filed. You have, of course, investor visas. They're not employment-based, but it's kind of based on business, at least not based on family. EB5, I-360 has to be filed, so it's not, there is no labor cert being filed there. The EB1 categories, based on if you have an L1 or you're a multinational executive, then it's directly an I-140 filing. There's no labor cert. Even for nurses and certain healthcare workers, if you belong to certain jobs that have a high demand and are designated as such as nurses and pharmacists. Nurses, and there's some other positions which are high demand. Such positions also, you have to file the labor. You have to prepare the labor, but you just send it out to USCIS. You don't send it. You don't need a pre-certified labor. So you prepare the labor, prepare the I-140, send everything to USCIS. So you don't have to test the job market because it's already decided that this is a shortage area. So those are some of the instances in which labor is not required. Also, in the EB1 category, if you are extraordinary ability, meaning that you are a renowned singer, or maybe an athlete who has won many awards, or a famous, renowned business person who has been, has come in Forbes or has come in other magazines or has received awards, they don't require a labor cert either. Or if you are a researcher, if you're in the researcher category and you have some publications, patents on your name, certain number of citations, if you qualify, then also you don't require a labor cert. So there are many instances in which a labor cert is not required, mostly EB1. But there's also EB2, a national interest waiver, which is possible, which is again extraordinary ability. You can self-sponsor, you don't need an employer, and you can file an I-140 directly. So these are some of the categories where a labor cert is not required.
Okay, that answers the question. So can you explain, the approximate timeline for the prevailing wage determination as well as the PERM?
So the prevailing wage takes about, again, it keeps changing depending on how busy they are, but it's taking about 4 months now. And because of that, we have a very short window to file, right? Because a lot of people don't want to wait for the recruitment period, which is 3 months, then again wait for the approval to come, which is 4 months, and then file. So they start off the process by, placing the advertisements where the wages are not required, as I said. So, and once you file once you get the prevailing wage, again, that prevailing wage is only good for a certain period of time. Because every year in June, new wages come out. So sometimes it could be that the prevailing wage is only good for 90 days because, June is coming up. So the maximum time it can be good for is 90 days or June, whichever is more. Sometimes it's good for a year because if you just got it in June of this year, then it's good until June of next year. So sometimes the situation might occur where the prevailing wage takes 4 months. You've started your ad process. The ads are expiring in 6 months. But after you get the prevailing wage, you have the wages, you have to place the NOJ because NOJ requires notice of job opportunity. Is the only ad that requires you to mention the wage. So you have to place the NOJ for 10 business days, and then you have to wait for 30 days. Right? So when you do that, the 6 months might get over. And then your prevailing wage might expire as well. So because of this time period that it's taking for the prevailing wage to get approved, sometimes we have to redo all the ads. And that's what's happening. So we're, hoping that the prevailing wage, they process it faster. So that's a big problem with the labor certs. Or employers have to just wait until the prevailing wage gets approved and then start the ads. Then it doesn't matter even if the prevailing wage, expires. So one important thing to remember is if you have done the ads after the approval of the prevailing wage, if you have started the ad process, then you don't have to worry about the expiry date of the prevailing wage. But if you have started the ad process before the prevailing wage approval, then you have to file the PERM before the prevailing wage expires. So as you can imagine, that gives us a window of like a month or sometimes less than that, 2 weeks, to actually file the PERM and meet all the requirements.
So there is no such requirement that you have to wait until the ads are in place. So PWD can just be filed and have it in place and then, take care of the advertisement and PERM process.
That's though it's a longer process, it's better to do it that way because then you don't have to worry about prevailing wage expiry if you do the ads after the prevailing wage gets approved.
And how about the PERM process? Let's say the PWD has taken about 4 months, or we already have a PWD. We can file PERM. I believe there is a certain period from the ads until the PERM is filed. And what is the period? And let's say after the PERM is filed, how long is it taking these days usually to get an approval?
So there is a wait time, if that's what you're asking. There's a wait time before you can actually file the PERM. So when you place the ads, you have to wait for 30 days before you can actually file the PERM, because the whole purpose of waiting is we're waiting for resumes. We're waiting for people. The whole idea of doing advertising is to make sure that there are no US citizens or permanent residents who are available to do the job. And therefore, we are filing the labor cert for this particular employee. So we have to test the market, and so we have to wait for resumes to come in. So there's a 30-day wait. And for the DOL, you have to actually place the ad for 30 days and then wait another 30 days. So that, that's a total of 60 days from the date that you first place the DOL advertisement. So that's why I said it takes about 2 to 3 months to even be able to file the perm. And 4 months even, because the prevailing wage is taking 4 months now. So yeah, the wait is 30 days. Then for NOJ, you have to place it for 10 business days, not calendar days, business days, and then wait for 30 days. And the ads expire. There's so many deadlines that you have to keep track of. So it becomes really difficult for the person filing the perm. The ads expire in 180 days from the date that they were first placed. So all these dates have to be kept in mind, and everything has to be happen, within that duration of time.
Okay, and how long is it taking these days for the perm to get an approval? An approximate time. I know it always changes. And also, can you tell about the new perm approval? It's not anymore, I believe, a physical copy.
Yeah, so it's taking, again, as you said, it keeps changing, but right now it's taking about 6 to 8 months for the perm to get approved. But of course, that process can be longer if there's an audit. And as I just said, the number of audits have increased significantly. So once you have an audit, then it can take up to a year for the labor cert to get approved. Yeah, so that is pretty much the processing time.
Okay, let's talk about this audit. You said there could be audit. So if there is an audit, you said it could take even longer, like a year at times. So is there any way that we can expedite it? And the other question is, if we cannot expedite it, what about the situation of a person who's, let's say, the H-1B is expiring in few months, or let's say H-1B is expiring in a year, and there's just a perm audit?
Yeah, that's why it's important to start the process ahead of time and not wait until you're in your 6th year of H1 and then file the green card. Because there are a lot of these things are not in our hands, right? We cannot predict the processing time. And as I was saying, if there is an RFE on the I-140, or if there's an audit on the perm, or if there's supervised recruitment, or if the case gets denied, then everything is out, all the timeline that you put, the tight timeline that you put for yourself is all out of the window. So if your 6 years are getting over on your H1 and your labor cert your perm is in audit, then obviously you have 2 options. You have to either change your status to another status and see if you can work in that status. If it's a status that gives you work visa, then you can. For example, if you can change to an H4 and then get H4 EAD, then it's possible to. If it's possible to do that, then you should change your status. And then if you want to get back onto a H1, then file a change of status again to a H1 once your I-140 gets approved. Because as you know, if you have an I-140 approved, you're able to file a H1 beyond 6 years. Another option is to leave the country and work remotely if your employer allows that. And then come back, file a H1, and come back once the I-140 is approved. Also, you have to remember that if your I-140 is not approved, but if you have already spent a year outside the country, you're eligible for a fresh 6 years. So you can come back even then, but you're subject to the H-1B quota, which means you have to wait until March. Every year the quota opens up in March. So you have to wait until March before you can actually file, for the H-1 again. Another way is to file a change of status to an F1, a student. And then if your university allows CPT, and if you have not taken CPT before or OPT before, then it's possible to do CPT, but please act with caution when you're getting on a CPT, but it's possible to continue employment that way. Or you can change to just a visitor's visa, in which case you can stay in the country, but you cannot work. So these are a few things that, or you can, if you're working for a multinational, you can leave and then come on an L1B if they, they have that certification for blanket L1s. So there are many ways of doing it. It depends on your particular situation. But my advice would be to don't wait until the last minute to until your 6th year on your H1 to file the labor cert. Do it in advance.
Okay. One question. I heard that if the perm is pending for over a year, you can get extension for a year based on the pending perm. Is it right?
Yes, you're right. So another way of getting an extension on your 6 years, if 6 years are over, is one way is, of course, if the I-140 is approved, which we just discussed. And the other is if 365 days have passed since the processing time of the perm, or processing time of the I-140. For example, labor cert is approved, but I-140 is pending for some reason or the other. So since the start of the process is if 365 days has gone by, then based on that, you can get, instead of a 3-year H1, you will get a 1-year extension on your H1. So that should give you enough time for the I-140 to finally get approved, and then you can file a 3-year extension.
Okay, sounds good. So yeah, the other question is there any way to expedite the perm? Like, we have a premium for I-140. Is there any such way that we can expedite perm or audits of the perm?
No, unfortunately, there's no process. There's no premium processing for labor cert. There is premium processing for the I-140, and you can definitely expedite, and most people file premium processing I-140 nowadays anyway. So that can be expedited, and that's really helpful, but the perm cannot be expedited.
Okay. Can an employer withdraw a perm either when it's pending or either when it's under audit? Let's say if there is some mistake and they can refile it, that makes the process a lot easier.
Yeah, if there is no audit, and if you have filed, remember you're filing online. So it's the perm system, the flag system that you're filing through. It's through the DOL website. Not yet, it hasn't transferred to the flag system as yet, but it will soon. But it's still online nonetheless. So you can withdraw it online itself, or it's quite a simple process. You just have to, click withdraw online. But if your case has been audited, and during the audit you realize that something was not done correctly, maybe an advertisement was not done, or maybe it was done but the wordings are different in each advertisement, or you put the wrong salary, or something has happened, some mess up has happened. In that instance, obviously the case is not going to get approved, but that doesn't mean that you don't respond to the audit. You still have to respond to the audit, but you can respond to the audit and then withdraw the case. If you do not respond to the audit and simply withdraw the case, then you will be subject to supervised recruitment, or you might be subject to some kind of a ban from the Department of Labor. They might say that for the next 2 years, all your cases will have to go through supervised recruitment. So you'll be blacklisted in some way. So anytime you get an audit, please don't ignore it. Don't withdraw without responding to the audit. So respond to the best of your ability and say that, look, we didn't do this, that's why we wish to withdraw, but here's the rest of the information that you asked for.
Yeah. So earlier the perm approval or the certificate used to be a blue paper, which is sent to be physical, and now I think it's all online. So let's say, when you are filing a downgrade and upgrade from EB3 to EB2 or vice versa, we need a copy usually. So the copies are available online, when you log in, like let's say a few years back copies?
So because of COVID, there's been some leniency with reference to many things. Deadlines, they've increased, right? They've given additional 60 days to respond to deadlines. They've given additional time to respond to audits. And so one of the other thing was that they've realized that it's difficult to get physical signed signatures. So they've allowed forms to be signed as long as it's a wet signature. Even the perm form can be signed, and a photocopy can be made, and it can be scanned, and then we can use a printout of it. The digital signature can never be used. So there's a difference between a wet signature and digital signature. If you use a digital signature, the case will get denied. So that's one concession they made. In addition to that, earlier the perm approvals used to come in a blue form, and originals used to be mailed. So now they have stopped mailing originals. Instead, it's emailed, and it's just white. It's on white pages. So it's basically a duplicate that is sent. There's nothing original, and so that it's easier for us now because we can just forward that approval to the clients, because 3 people have to sign on the perm. So it's very hard to coordinate 3 original signatures. But now it's easier for us because we can just get photocopies of signatures on, otherwise we'd have to send each page to a different place. So one page would go to the beneficiary, one page would go to the employer, and we would keep, one of the pages. And what would happen is sometimes pages would get lost, and we would have to then file, even though we have the rest of the pages. Even if you don't have one page in original, you'll have to then file the I-140 and ask the Department of Labor, ask the USCIS to request a duplicate copy from the Labor Department. And that is a very lengthy process for them to do that. And so mostly in those cases, premium processing is not allowed. So now, because copies are being sent out, and so there's no concept of original or losing the original, that has become much better for us because we don't have to now worry about losing original documents.
Got it. Okay. Just a message to viewers that if you want to reach Attorney Prashanthi Garu for private consultations, please reach at 212-354-1010 or prashanthi@reddyesq.com. Again, I would like to repeat the disclaimer here. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV News and agents are not responsible in any way for your actions. Use this information at your own risk. If you need any consultation, please reach out to an attorney. If you would like to reach Attorney Prashanthi Garu for a consultation, again, reach at 212-354-1010 or prashanthi@reddyesq.com. Okay, coming to the next question, how once the perm is approved, how long is the perm valid and how long they have to file an I-140?
So the perm is valid for 6 months. So within that 6 months, you have to file the I-140. If you file beyond the 6 months, then simply the I-140 gets denied, even if you try to file it. But of course, there are exceptions to that, which is basically if you have previously filed the labor cert already, and they already have a copy of it, because you've maybe filed it and it got denied, so you're refiling it. In that instance, number one, you will not have the original perm, which is fine. And second thing is that you don't have to adhere to that 180 days deadline. So that's an exception. Or also, like we have done recently, downgrading from EB2 to EB3. You don't require the original perm because they already have it. You don't have to request the DOL for a duplicate. So that process, we don't have to encounter that process. It's a normal process, and we don't have to worry about the 6 months deadline for the downgrade also. So these are labor certs that were approved in 2009, 2010, 11. So obviously the 6 months is already over. So these are the two exceptions. Refiling or an amendment, you don't have to adhere to the 180 days certification rule.
Okay, got it. Okay, the next question. Can the perm be filed for a part-time employment unlike the full-time?
No, unlike a H1 where you can actually file for a part-time person by indicating the number of hours, a green card is a permanent position. It's for a full-time permanent position. So you cannot really file for a part-time position. So yes, it's unlike the non-immigrant visas. For this, it has to be full-time and it has to be a permanent position.
Okay, got it. So another question, let's say an advertisement and perm, the advertisement is for EB2 category, like needs masters with few years of experience or bachelors with 5 years of experience. Can a perm be still filed as an EB3 even though the ad is given EB2 category?
So when you file the perm, you give certain requirements and you cannot change those requirements later on. So if you're saying the requirement is master's plus 2 or it's bachelor's plus 5 or whatever it is, you can't change that requirement. If you want to change the requirement, then you have to file a new labor cert, right? So, but what you're doing in the I-140 when you downgrade is you're not changing that requirement. The beneficiary still has to qualify based on the original requirements in the perm application. But yes, you can decide which category to file in. You can decide to file it in EB3 if you want. Because if you qualify for EB2, obviously you qualify for the lower level, which is EB3. But the reverse doesn't work. If you qualify for EB3, you will not qualify for EB2. So you don't have that choice. But you do have the choice of downgrading. And even though you overqualify, you can still ask for EB3. So that's what you're doing. You're not changing the qualifications in the perm, or you're not changing the qualifications in the job offer. It's the same.
Okay, can it be done this way? Like, can they file two different petitions, one as EB2 and EB3, just to keep both?
Right. So I-140s you can keep. That's what we did in October. We filed a new I-140. There was a controversy about that, though, whether it can be done or not. But we filed a new I-140 and kept both the EB2 and as well as the EB3 numbers. We kept both applications. So tomorrow, if the EB2 becomes current, then they can cross-file using the EB2 I-140. So that was the whole purpose of doing that. Some people wanted to do amendments, so which is basically you're amending the existing I-140 to an EB3, in which case then the original I-140 is lost. But if you file a new one, then you're not amending, you're filing a new application. So both are, and you're using the same labor cert. There's no separate labor cert. You're using the same labor cert, but you're, just have two I-140s filed because you can choose which employment-based category you want to file in.
Yeah, got it. So recently there's a premium fee increase, for a few of the applications. Is it also applicable to I-140?
Yeah, 2,500 is the fee now for the I-140 as well.
Okay. Do the applicant have to include, or it's optional to include the family members in perm or I-140? If so, what are the consequences?
So in the labor cert, there is no option to include family members. They don't ask for that. That's not the purpose of it. The purpose is simply to look at the job, see if there's any qualified applicants, and if there isn't, then the DOL would certify that job is a green card can be filed for that person. So when you file the I-140, that's the immigrant petition. That's when you're actually filing the immigrant visa, and you're including your family members. You're letting them know whether they're in the US or if they're abroad, etc., etc. So that's done at the I-140 stage. But for example, if you're not married at the I-140 stage and after that you get married, you can still include family members. But if you were married but didn't include your spouse, then you might have to file an amendment in order to file a 485, for the missing family members.
The next question is, can the applicant leave the country if there is an emergency when the perm is pending or when the I-140 is pending? If so, there are any consequences?
So focusing on the labor cert, there is no issue with leaving the country if the labor cert is filed. There's no issue even at the I-485 stage. But if you file a family-based application for 485, then You can leave the country even then, but you have to file for advance parole, get the approval, and then leave. If you are filing for 485 based on employment, then you can leave the country. There's no problem. You don't need to get an advance parole. You can leave and come back on your H1 or whatever visa you have, as long as you have a means of coming back. And for that, to answer your question, for the labor cert, no, there's no such requirement that you have to stay in the country once the labor cert is filed. You can leave.
How about 140? How about 140?
No requirement for I-140 also.
So, okay, it doesn't really matter even if they had to go for a bit. Okay, we have a question offline. It's little off the topic, not completely. So one of the viewers, he had filed for the 485 using the filing dates in the month of October. The dates were current then. I mean, the filing dates were. But then the dates moved back a year last month. So USCIS returned the application saying that, you are not in the filing dates, even though at the time of filing, he was in the filing dates. I mean, it was between Jan 2014 to Jan 2015. When the case received, they are current, but, USCIS returned it saying it was probably a mistake. So what can be done in this situation,
That's unfortunate because it seems like USCIS error. But even in a situation where USCIS has committed the error, if the visa numbers are ultimately not available when in order to refile, they won't accept it. So even though the error is on their part. So this is, I think, a really good case for district court because they will not accept it now because they will just say that our hands are tied. Even though the error was from our side, we cannot accept the case because the visa bulletin, won't allow us to accept it. There's no exception which says that if USCIS makes an error and if the visa number is not available, you can accept a case. So in the law, when there's no such exception, the officer cannot make that exception. Maybe a judge can, but I don't think that case will be accepted if the visa numbers are not there. Okay,
we have a caller. Yeah, sorry to interrupt you. We have a caller. Let's take the caller and then we can continue on it. Hi, Sweta. Welcome.
Yeah, hi. Can I talk to Prashanti?
Yeah, you are on the air. Please go ahead.
Okay, thank you. Prashanti, this is Shweta and I'm calling from DC. I have a question related to one of my H1Bs. I'm currently working for an employer and now that I got a new opportunity, so as it's work from home, I think I can manage the two jobs. So I was saying that we can file a concurrent employment. So now my question is, if in case I'm filing a concurrent employment which says like full-time opportunity as a no, and in the future I'm comfortable continuing the second opportunity which I choose, the concurrent filing, and I leave the opportunity with client A. Do you think like I should file an amendment again for the concurrent employment? How does it work?
So concurrent employment is when you choose to do two jobs. When you'll file the first H1 as a normal H1, and the second H1 that you file, you will file it as a concurrent employment. So it's not an amendment. You're filing a new H1 as a concurrent filing. Just something to be careful when you're filing a concurrent H1 is that the number of hours that you're going to be working. I mean, it's possible to work two full-time jobs, 40 hours and 40 hours, 80 hours in a week. Some people do work 80 hours. So, but if it's beyond that, then it might not be believable. So just keep the hours to, a believable number. And so the second H1 will be filed as a concurrent H1. And then you can work for both employees at the same time.
I got it, Prashanti. The question is if in case I think like I'm not comfortable managing the both jobs. If it is not manageable for me in the future, I would, if in case, I think the concurrent filing client is a long-term opportunity. I feel like what if I leave the other job in the future, do I need to refile it again?
So if you want to leave your second job H1 that you filed, you simply withdraw it. And you don't fall out of status because
No,
you
So
have.
there won't
she's
be any
talking
problem.
about if she wants to leave the first job and keep the concurrent filing.
Yeah, you
Since
can
it
do
is
First job,
that
filed
yes.
as
also. You can do
Yes.
either one. You could do either one. As long as you have one H1, you can stay in the country using that.
yeah, since it was filed as a concurrent filing,
Okay.
is it necessary to amend it because
No,
she's
no, it's
now
not
only doing
necessary to
one
amend
job?
it. You can just,
Yeah.
it's a H1 and it's a, it's valid.
Okay, that shouldn't be a problem if I carry the same LCA which says like concurrent employment throughout the approved period, right?
That's fine. That's fine. It doesn't matter.
Yeah, that was my concern. Yeah, thank you so much.
You're welcome.
Yeah, Prashant, going back to the previous question again, in that situation where it was an USCIS error, what can be done? Can it be taken to court? A court case be filed, because we know that this is once in a lifetime opportunity. We don't know if again dates would be even anywhere near. So, what advice do you give? Is it suggestible to file a petition in the court because it clearly is a USCIS error?
Yes, the only remedy would be to go to district court. So even there is a law. I mean, the law is there. So even the courts can only interpret the law, but even courts can't change the law. So I don't know to what extent it will be successful, but maybe they can interpret it in such a way that the original law was not meant to punish people, even though it was no fault of their own. Maybe it can be interpreted in that way, but otherwise, even courts cannot make the law. They can only interpret the law as it was meant to be. I think that you can always try to resend it back to USCIS and say that you made an error. It was, the visa number was available. Please accept this as, filed on time, as if it was filed on time, and see what happens. But most probably they won't accept it, but there's no harm in trying.
Okay, got it. Okay, we are towards the end of the show. Before we conclude the show, can you please provide some information on your law offices, practice areas, and your expertise, so the viewers would be seeking advice or consultation if needed?
My offices are in Midtown Manhattan, and I've been practicing immigration law since 1997. I do employment-based, family-based immigration law. So, my email address is prashanti@reddyesq.com. You can call me at 212-354-1010, extension 107. We'll be happy to help with any questions that you have.
Okay. Again, before we end the show, if you have any questions, or if you need legal consultation or a private consultation or help with any immigration petitions or family-based petitions, please reach out to Prashanti for a private consultation at 212-354-1010 or prashanti@reddyesq.com, and the website is www.reddyesq.com. Again, I would like to repeat the disclaimer here. Please note that the show does not provide any legal advice. It is general in nature, and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. So to summarize, today we have learned about the PERM and the process before and after the PERM. And stay tuned and keep watching the show, so we can continue the next topics after what happens with the labor and the next steps of filing I-140, and then followed by I-485 or adjustment of status. Before ending the show, one quick question, Prashanti Garu. What do you think? The visa bulletin now, they are only accepting final action dates. Do you see any progress or any change in this scenario going forward, or will this be like this?
We were actually, usually every year they accept dates for filing They accept green cards under dates for filing, at least until March every year. But this year, obviously, they haven't done that. Obviously, it looks like thousands of people have filed during that October to December timeframe. So the numbers got over faster than anticipated. We don't expect any change. We were hoping for that law, right, to pass, but that hasn't happened. So let's hope that the new administration can do something about this issue.
Okay. Thanks, Prashant Garu. Thanks for your time. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday at 5:30 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks, Prashant.
Thank you.